Shirin Jaslin Anak Cefi, and I am student of Netherlands of Maritime University College. In this presentation, I will explain about the dangerous good in the context of maritime law. So today, I will explain about the dangerous good of the context of maritime law. Here, I will cover the three main points that I will prepare in my infographics. So first, what is dangerous good? Dangerous goods are cargoes that may cause harm to the vessels, the crew, or the cargo if not properly handled, packed, or declared. Under international maritime law, both shipper and the ship owner must comply with the International Maritime Dangerous Goods Codes, also known as IMDG Code. The IMDG Code provides standards for the classifications, packaging, labeling, and documentations of hazardous material during the sea transport. The International Maritime Dangerous Goods (IMDG) Code, developed by the International Marine Organizations (IMO), that provide a standardized system for classifying, packaging, marketing, labeling, and transporting the dangerous goods safely. So, under the IMDG Code, the shipper and the cargo owner, which is the shipper, are both responsible for ensuring the compliance. The shipper must properly declare and label any cargo that is considered dangerous. The carrier or the ship operator must ensure that such cargo is properly stored and secreted to prevent the risk to the vessels, the crew, and the other cargo. Non-compliance with this code or with international conventions such as SOLAS and MARPOL can result in the detention of the vessels, heavy fines, and even suspensions of license. This code is developed under the International Maritime Organizations or IMO, and it is mandatory under the SOLAS conventions. The IMDG code classifies dangerous goods into the 9 classes such as explosive, gases, flammable liquid, and substance, corrosive materials. It is also developed details, rules on how it pack, label, document, and store these goods safe on the board shipping. So, next is I will talk about the common law positions on dangerous goods. Under common law, there is an implied obligation that the shipper must not ship the dangerous good without giving notice to the carrier. This obligation is strict, meaning the shipper can be held liable even if they did not know the cargo was dangerous. As well known, the case illustrated this principle is Effort Shipping Co. Ltd. Bill Liden's Management SA, the Chinese NK 1998 AC 605HL. So, in this case, the vessel Chinese NK was carrying wet and groundnut extractions meal pellets. The groundnut cargo was found to be infested with carpa beetle, which is the highly dangerous to be stored products. As a result, the ship was quarantined and some cargo had to be gestioned, causing long delay and financial loss. So, the House of Lords held that the shipper had breached the compliance obligations not to ship dangerous goods without notice, even though the shipper didn't know about the infestations. The court decided that the obligation is strict. Once the good causes danger to the ships or the other cargo, the shipper is liable. So, The cargo is therefore considered as dangerous good under Article IV Rule 6 of the Hague Rules. This case confirmed that dangerous goods are not limited to explosive or toxic substances, even though their cargo that can be causes physical damage or contaminations may fall under the definitions. It also highlights that the shipper must be strict liability for failing to inform the carrier of the nature of the goods. First, under the international conventions, like the Huge Rules and the Solas Conventions, carriers have the right to discharge, destroy, or render harmless dangerous goods shipped without proper notice. The shipper may be held responsible for any losses, damage, delay, or injury resulting from the goods. Authorities may impose fine or other penalties on both the ship owner and the cargo owner. Second, non-compliance can lead to detentions of the vessels, quarantine, or injunctions of entry at ports. The third, under civil liability, the shipper may face claim for the damage from the carrier, insurance, or the other cargo owners. For example, the Chinese NK, the shipper had to be computes for the losses caused by quarantine and delay. So next, I will talk about the issue number 2, which is shipper liability when the carrier know the goods are dangerous. The second issue concerns that the shipper liability when the carrier already know the cargoes are dangerous goods. Sometimes, the shipper or the carrier may already know that the cargo dangerous nature before loading. But in this such case, the shipper liability become limited because of the ship owner knowing accepted the risk. So, this is the illustrate in the Malaysian cases of Bitachem, Selian Berhad v. Inhua Fu Marine Lines SDN-D in 2013. A shipment of agricultural chemical product causes damages to the ship during the voyage. The cargo held since the ship owner was aware to the dangerous nature of the goods and still agreed to carry them, then the shipper was made not fully liable for the damage. In conclusions, the dangerous good requires strict attention under both international codes and the common law. The IMDG code provides a clear framework to ensure the safety of the ships, the crew, the cargo, while the common law reinforces the accountability through implied obligations. The carrier of dangerous goods under a voyage charter party requires strict compliance with the IMDG code and international safety conventions. Under common law, failure to declare dangerous goods makes the shipper strictly liable for any losses or damages. However, when the ship owner knowing accept the risk, liability must be shared or reduced. To ensure this shipper and the ship owner, they must maintain their duty of care to protect the vessels, the crew, and the environment.